Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bichard. Today I read the case, Matter of Cohn versus Suffolk County Board of Elections, 109 AD 3D 538, New York Appellate Division, 2nd Department, 2013. Friends, today I have something for you. What is that something? Find out. Friends, we're talking about the Working Families Party again. Have you ever voted for them? Would you ever vote for them? That's something to think about. This case is a page long. It has something for us to consider. The Working Families Party candidate here, Marianne A. Cohn, wanted to get on the ballot. So let's read from the record. It says, quote, in a proceeding pursuant to Election Law Statute 16-102 inter alia to invalidate a petition designating Anthony M. Gralato as candidate in a primary election to be held on September 10, 2013 for the nomination of the Working Families Party as its candidate for the public office of Suffolk County Legislator for the 8th Legislative District, Anthony M. Gralato appeals from a final order of the Supreme Court, Suffolk County, Mackenzie J., dated August 2nd, 2013, which granted the petition, invalidated the designating petition, and directed the Suffolk County Board of Elections to refrain from placing his name on the ballot, end quote. We don't like it when our third-party friends can't get on the ballot. So what was their rationale for denying him on the ballot? Looks like it was something of an issue of a technicality to me. Looks like it was a petty thing. Looks like they were grasping for straws. So what specifically was it? It says, quote, pursuant to Election Law 6-132, parentheses 1, a person seeking a nomination as a candidate must provide on the designating petition, inter alia, the name of the political party whose designation the candidate seeks. Here the petitioners contend that Anthony M. Gralato's designating petition was properly invalidated because it identified the Working Family Party rather than the Working Families Party as a party whose designation he sought. The petitioners contend that while the Working Families Party is a duly constituted and properly registered political party in New York, the Working Family Party is not a registered or recognized political party in this state, end quote. What motivates a person to file a lawsuit like that? If they think the Working Families Party is this petty third party that has no chance of ever winning, then why not just let them get on the ballot? I believe the reason somebody files a lawsuit like that is because they want power. Instead of going after someone big, they're going after the underdogs here. It's cowardly to strike the underdogs down. It's brave to raise the underdogs up. This is a petty issue. And this person is standing on a hill in regard to a petty issue. So friends, do you think this court found validity in this issue? Let's see what they had to say. Although it is undisputed that the designating petition contained an error in the naming of the political party for which Gralato sought designation, a petition should not be invalidated where there is no proof of any intention on the part of the candidate or of those who have solicited signatures on his or her behalf to mislead or confuse, and no evidence that the inaccuracy did or would lead to misidentification or confusion on the part of those invited to sign the petition. Here there has been no showing of any intention to mislead or confuse, and no showing that the inaccuracy in the designated petition did or would lead or tend to lead to misidentification or confusion on the part of those identified to sign the petition. Inasmuch as no such showing was made, the designated petition was improperly invalidated. The appellant's remaining contentions are either unpreserved for appellate review or without merit. End quote. In that one-page decision, they stuck it to the appellant here because it was not what needed to happen. Do you think a spelling or usage error should invalidate a ballot access petition. I don't. I don't think that it should, especially in this case where it was a small variation on the name. Indeed, like the judges said, we knew who they were talking about, so there was no issue. Nonetheless, Mr. Cohn tried to invalidate this petition. But the underdogs here won. They won. The underdogs won. In real life, sometimes the underdogs can win. This proves it. Way to go, Working Families Party. Long live third parties. Goodbye.